All of this to say, outrage earns a lot of views. That's true. But when outrage is misplaced or unfounded, then somebody needs to call it out and say, I understand that you don't really know what's happening here, that your outrage is really just ignorance. Well, we're back to running, so that's good news. It's not much, but it's something. We're on a walk, run, return to run program, so back to it, and pretty soon I'm going to have some long runs coming up. I don't listen to music very often when I'm running. It started as a habit when I was doing triathlons, because you're not allowed to have music during those races anyway, so I just started training without it. And so now I listen to podcasts if I have anything to listen to, generally true crime, but also I think a lot about various things. Do a lot of math, trying to calculate paces and distance and figure all that kind of stuff out on the run that makes my brain work and helps me stay engaged but disengaged from bodily pain. What I'm going to talk about today actually has a little bit to do with my professional background. See, I am a lawyer. I work in-house at a tech company, but I have a specialty in intellectual property. I don't get to use it very frequently, but it is fun for me to think about the various issues in popular culture that have to do with intellectual property. And another YouTuber friend of mine sent me a video of TheTekkitRealm having this issue with a Minecraft map build that he did, and his concerns and his assertions that the claims are completely unfounded. So briefly, this person has spent, in collaboration with a number of other Minecraft designers, better part of 5 or 6 years building what they purport to be the world's largest Minecraft map environment. I don't play Minecraft, so I don't really know exactly the terminology. But the particular thing at issue here is a building that has the MetLife logo on it. He is upset because MetLife has essentially gotten the map removed from a number of different websites where players could download that map and then use it, interact with it, build onto it. I'm not exactly sure. The MetLife building in the map itself seems to be his major stumbling block. From what I could tell from the images posted in his video, which is now unlisted, it is the only building in that map that has a logo on it. He may have skipped over a number of others that I could not see in the still shots from his video, but to my eye, that was the only one that had a logo on it. So MetLife has said and has told these various websites where you can download it, you need to take that down, it violates our trademark. And so they're suing him for a trademark violation, which basically means MetLife believes that there is a likelihood of confusion that MetLife has sponsored this build in some way. That's my guess. A lot of this is going to be speculation based on my knowledge of trademark law, based on how the companies I have worked for enforce their trademark rights, and just some educated guesses what could be going on behind the scenes, right? Let's understand first that trademark is an indication of source. So when you see a Nike shoe, you understand that swoosh means the shoe was from Nike. And if someone else builds a shoe and puts that swoosh on it, Nike has registered their trademark and they have the right to say, you can't sell that shoe because people are going to think it's my shoe, and that's not my shoe. So what MetLife is doing here is saying, you put our logo on a building, people are going to think that that is something we did, or we instructed you or granted you the rights to do. And this happens in video games all the time. Think about every racing game you have ever played and all the logos within that game. All of those logos have been paid for. They've paid the original source of those logos, whether that's the car or the sponsor of the car. All of those people have been paid to use that logo in the game. Same is true for sports games. If you see a logo within a sports game, that logo has been paid for. Same is true with first-person shooters. If you have a firearm in that game that has a name to it, then it has likely been paid for to the manufacturer of the physical good, has been paid to use that trademark in this game. That is how it has worked time immemorial. There's a little bit of indignation from this creator to say, well, why are you coming after me, crazy corporation with millions of dollars? I should be allowed to make a video game version of a real world place. And while that's true, you may not use the logos found in those real world places without paying for them. That is well established in the law. So there's a little bit of ignorance happening there. You can sort of overlook that. You take the logo off, you're probably fine. And that would have been the end of it. But he refused, and the creators have refused to take that out. So now they're getting sued. This creator is saying, I haven't made any money on this project. And no one else who has contributed to the project has made money on it. And that's not exactly true though, is it? Because there's a Guinness World Record attempt happening here. So there's a lot of publicity around it. It's being purported as the largest build in Minecraft history. So there's a lot of advantage to saying you can download the largest map ever created. I made it. We made it. There's potential financial gain there. Your YouTube channel, as of today, has 1.74 million subscribers. And all of them have watched you participate in this massive build. So of course there's financial gain. Whether you want to attribute it directly to that build or not, whether you can draw a direct line is irrelevant. The fact is that build has formed a basis of your popularity, your, for lack of a better term, your celebrity within that world. It may not be, I have sold this map 1 million times and every time I sell that map I earn $10. That's not what this is about. This is about the surrounding economic circumstances, sort of the macro world of this map development for you and for others that you can tie your name to and say, yeah, this is the biggest one in the world. I made it. Now I am sought after as a potential Minecraft developer for myself or for others. Who knows? I have probably earned some YouTube revenue for showing myself building these things. I certainly have earned, until the video was unlisted, YouTube revenue from the ads, from the 375,000 plus people that watched the video prior to its delisting. These things all mean financial gain for you, whether you want to acknowledge it or not. And if you have earned that money on the back of someone else's trademark, they are entitled to that money, not you. So there's a little bit of a misunderstanding there of how all of this works together. Now, if you can prove that YouTube revenue is unrelated to this specific project, which is going to be very difficult to do, you can retain some of that money. But what they're likely going to say is, you gained celebrity status by creating this enormous Minecraft map and saying that it's the biggest one in the entire world, and you included our trademark in those videos, and that has led to an increase in your subscriber count, an increase in your view count. Therefore, the revenue that you earned as a result of that increase belongs to us. And there's going to be a massive battle about how much of that is attributed to the use of the MetLife logo in the map and how much of that can be attributed to other things that you do, whether that's within that map or outside of it, or totally unrelated to Minecraft at all. It is going to be a very difficult situation to sift through and find what revenue might actually belong to MetLife. So then there's this piece in the video as well about, they're threatening me with jail time and they're threatening me with $150,000 in fines. Yes and no, right? So when you file a lawsuit, it requires that the defendant, in this case the content creator, must show up or file a response in some form or fashion. Filing a response can be done by hiring a lawyer. That's expensive, obviously. They're going to file a response brief and they're going to cite all this case law that says why their position is right and the other position is wrong. But eventually you are going to have to probably show up in court unless you can solve it outside of court. And you kind of ignored their attempts to do that. So now they're kind of left with no other option but to say, show up or find yourself in contempt of court. And that's where the jail time and the fines come in. It's not about the trademark issue itself. It is not about MetLife threatening you with that. This is about them saying, if you don't show up to court, then the court can find you in contempt. And the maximum sentence that could be imposed for a contempt of court charge are the jail time and fines that this content creator has cited and shows the letter talking about, like $150,000, 6 months or 6 years in jail. I don't remember exactly what. But listen, those are maximums. If you're a first-time offender, it is extremely unlikely that you will be sentenced to the maximum for anything. It's going to have to be a very serious crime. You are not going to be, most likely, subject to a crazy long jail sentence or an extremely large fine, like $150,000, as a first-time contempt of court offender. You know how you avoid all of that? You show up. You go to court. You get your lawyer. You show up at the courthouse and you talk about it with the judge. This is a very easy problem to solve. You're not going to find yourself in jail with a massive fine if you just show up. Usually, you get like 30 days to 3 months to 6 months notice of when that date is. So it's not like you have to jump on a plane right now, rush to the airport and get on a plane and be there tomorrow. That's not how this works. I understand, like, there's a lot of scary elements to this that show up in letters, but if you step back and ask 1 or 2 questions or think about it for more than like a half a second or two, you're going to find out, like, this is not as serious a threat as it might initially seem. Yeah, so the shortest version of this story is that it is an open and shut trademark case. MetLife 100% has the right to say, you may or may not use my trademark. And any creator who's considering using a trademark in their videos should be aware of that. Now, I want to say very clearly, though, there is such a thing as nominative fair use. Meaning, if I am talking about MetLife in my video and discussing a factual circumstance, I'm allowed to use the MetLife logo to say, this is what I'm talking about. All of this to say, outrage earns a lot of views. That's true. But when outrage is misplaced or unfounded, then somebody needs to call it out and say, I understand that you don't really know what's happening here. So let me help you understand so that you can see that your outrage is really just ignorance. I'm sorry that you have to face consequences for prior ignorance, but it's not an excuse. And you do probably actually owe them some money. And they do have the right to tell you that you can't use their logo wherever you want most of the time. If you find this interesting, if you got value out of this content, share it with your friends, share it with your enemies. I'm not that picky. In the meantime, do all the YouTube algorithm things, like, share, comment, subscribe, and I'll see you in the next one.